The Indian Land Consolidation Act, or ILCA, of 1983 was an attempt by federal government to fix some of the problems associated with Indian claims. Remember what an Indian claim is, what we mean by an Indian claim or tribal claim?
Claiming of the land.
Remember when we had the Indian Claims Commission from mid-1940s to the mid-1970s? That Indian Claims Commission was a kind of a tribunal to allow tribes to petition the federal government to correct some of the errors or just outright wrongs of the reservation process and the treaty process way back in the 19th century, mostly the 19th century. And the Indian Claims Commission was basically a court that would hear the tribe's complaints, hear the tribe's case, and then make a ruling on it. But because of the way we do things in the United States legally, rather than just hearing the case and then making a decision, the way we did it in the United States is we had a plaintiff and we had a defendant. So the Indian tribes were the plaintiffs and the government was the defendant. And so the government had its own lawyers to check the arguments and facts put forth by the tribal lawyers. And these were lawyers working for the tribes, not necessarily Indian people. But the lawyers working for the tribe's claim. So a claim is what we mean by a claim in this course is a claim of interest of some sort against the government or against an individual. Most of the time we're talking about the federal government here. So the Indian Claims Commission was a commission set up to right past wrongs, and usually that was done through some sort of settlement, some sort of cash settlement, if it happened at all. And there was an accounting system that went along with it. But the main thing that I wanted you to get from that is that it was not just hearing complaints, it was also an attempt to get at the facts. So the government had their side, and the government lawyers would try to disprove anything that the plaintiff's lawyers were arguing for. The idea that you triangulate the truth somehow, it was the point. So it wasn't always a giveaway to whatever tribe had a complaint. Indian Claims Commission. Well, the Indian Land Consolidation Act was similar to that. It was initially it was set up incorrectly and found unconstitutional because it violated the Fifth Amendment. What's our concern in this course, Geography of Indian Country, with the Fifth Amendment? Paul? This will be a good test question. Quiz question. What in our course, Geography of Indian Country, how does the Fifth Amendment apply to the things that we talk about? What is the Fifth Amendment?
Basis on them owning land, is that what you're trying to say? Like, it did like.
What are the various parts of the Fifth Amendment? Recall?
It hinders.
I'd have to check my phone, check my Constitution. You should all carry a Constitution with you. By the way, constitutional carry begins November 1st in the state of Oklahoma. You know what constitutional carry is, I guess.
You want me to say?
So when you go to Walmart, well, I don't think they're going to allow them in Walmart. When you see people carrying sidearms openly, They don't have to have a permit, they don't have to have any sort of training or licensing. What do you think about that?
What, you ever been to Honduras?
Well, okay.
It's nerve-wracking when everyone has a gun.
Honduras and Oklahoma are a lot alike, right? Yeah, well, anyway, that's our new law that goes into effect November 1st. College campuses are not included, so it's don't bring your sidearm to campus unconcealed. Don't bring your sidearm to campus, period. By the way, to carry it openly, you're supposed to be 21 or active military or a military background, age 18. So, but you can carry firearms in your car. You just got to be sure when the highway patrolman pulls you over for speeding that if you don't let them know that, then that's a misdemeanor, okay? Or it's that may be a criminal offense. Anyway, I'm looking for the Constitution, sorry.
Do you want to say the Fifth Amendment?
Did you get it already?
Yeah.
Oh, okay. Go for it.
No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land of naval forces or in the militia, when in actual service in time of war or public danger.
All right. That is actually something we discussed. Remember that?
Yeah.
What case was it?
Oh, shoot.
We talked about Talton versus Mays. Remember that? Talton versus Mays was an attempt by a Cherokee Nation citizen, to have his capital crime or his execution by the Cherokee Nation, which was scheduled, to have that thrown out and disqualified. And so that was one good example of a test of sovereignty. So you got the Fifth Amendment out. We were talking about the Fifth Amendment and how it applies to this class. That example is interesting, but that's not exactly what I was looking for. Right? So how does the Fifth Amendment apply to this class most of the time? Geography of Indian country, that is land. That's the clue. So what are some other facets of the Fifth Amendment? We all know the one, where you got to have your Miranda rights read because you can't self-incriminate. Right? You don't have to say anything that would be incriminating in a court of law until so you don't have to say anything. You take the Fifth, right? What else does the Fifth Amendment do? It has to do with the taking. Remember what we were talking about earlier with the taking?
Land.
Land. So the Fifth Amendment requires, you see anything?
Well, basically, like,
I'm just guessing because of how you said.
oh, okay.
I upscaled my equipment here. Got a new microphone. Hopefully this thing works.
It says like, nor shall any person be subject for the same offense to be twice put in jeopardy.
The double jeopardy issue too, yeah.
Double jeopardy.
Yeah, so you can't be tried for the same offense unless it's in a civil court.
Yeah.
So criminal versus civil.
And then, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law.
There you go.
Yeah.
There you go. Due process of law, property. Those are the key words. So what does that mean?
They just can't like take your thing.
They can't. The government just can't, take it.
Yeah, they just can't.
Well, they can't take it, but they just can't take it and say sorry.
Yeah.
They can take it, and they have to compensate you. They have to compensate the owner of the property based on what? Whatever is fair. So in this, most of the time you hear the phrase fair market value. So this means, hey, there's a log laying down here on the floor. Why is that? Why is there a log laying here? This actually has something to do with Indian country. And it was a prop for my previous class, but I can use it a little bit here. This log came off a barn, an old log crib, double crib log barn in Adair County. It came off of the barn yesterday, and it got here in the back of my pickup. All right, and I got another one out there too. But this is what we're going to do with this is we're going to try to do a little dendrochronology on it and see how old it is, so we can get an idea of how old that old barn was. But anyway, I don't normally go around tearing barns up. I usually go around trying to save them. But in this case, this thing's getting ready to get dozed. All right, it's too bad, but it was kind of falling down, and they need better roads over there in Adair County. So there's going to be a road going through it, and so the thing's going to be torn down. The owner said, "I'm ready for it to come down and get rid of it." You know, so I said, "You mind if I take a couple of logs?" He said, "Help yourself." So I got my saw out and eventually just started taking logs and took a couple of logs off. Okay. Now the reason I was even there was because that property owner is having a road built through his property, okay? And he owns this old log house. He doesn't live in it. He lives in a nice brick house down the road, but he owns this old property, and it has this old log barn on it and an old log house. And this is in Adair County, which is in the Cherokee Nation area, right? And the road that is being built is actually being built by the Cherokee Nation, okay? Cherokee Nation Roads Department. So the Indians, okay, the Indian tribe is basically, eliminating some of the cultural landscape, and that's why they called me, is because I go out and I photographed it and measured it, and now we'll have a record of it now that it's going to be gone soon. And I got an opportunity to do some dendrochronology stuff on the log, so that was kind of neat. That's one reason I was attracted to it. But the point of that is that guy's property, it's his property now, but it's been condemned for that new road. You know, it's actually a road alignment. They're trying to make the road a little safer. So they condemned his property, and of course he's not too upset because he's being compensated for fair market value for the land. But what are the real problems? Who is experiencing the real problems when it comes to fractionation?
The property owner.
The individual allottee, the individual Indian tribal members who are heirs to the original allotment. And there may be dozens or even hundreds of them, okay? So what does that do? What does that do when you have, say, let's just say 80 acres and, let's just try to keep it conservative, 80 acres and 20 people own it. And say you want to lease and it's restricted. If it's restricted, who is the authority that can allow for that land to be leased? The Bureau of Indian Affairs. Bureau of Indian Affairs. The federal government has to authorize a particular contract for the use of that land, whether it's for farming or whether it's for a tobacco smoke shop or whether it's for the idea was to take that property, and because it cannot pass into the ownership of heirs, it would be turned back over to the original property. All right, so the president said this was about non-Indians, individual possibly losing their claim to the land that had been passed to. Does that make sense? So what the court said, the court said tribes can't basically repossess the land simply because it can't pass down to us. Even if it's under where it's under fractionation, even if it's fractionated to the ability to reasonably utilize it economically, and therefore economically it would have to be abandoned. Even with that, the court's ruled that this would be a taking. This would be a taking of property by tribe that would not conform to the Fifth Amendment of the United States Constitution. Okay, follow me on? So we had a solution. The solution was, well, let's tell the party to sit out here and anywhere. They house it because they live there, everybody owns it, but people own property, don't find it. Instead of saying, let's get back to tribe, which may be a thing. Of course, that's not constitutional. That would be an unfair taking of the We've talked about hunting and fishing rights a little bit, and I've talked a little bit about how hunting and fishing rights tend to be fairly durable for Indian individuals, individual Indian people. And we can see some examples of this. But even Public Law 280, in which, you remember, I want you to be able to tell me what Public Law 280 did, right? So how would you explain that in an elevator to somebody? You know? What does Public Law 280 do? It's an example of how Congress can use its plenary power to authorize the states to have jurisdiction. Yeah. So the Congress in this case actually handed jurisdiction to the states over Indian country within their boundaries. So there are these states that have received jurisdiction over Indian country within their boundaries. But the point is, even Public Law 280, which is kind of the extreme when it comes to states having authority, even when it comes to Public Law 280, Public Law 280 can't deprive any Indian or any Indian tribe, band, or community of any right, privilege, or immunity afforded under federal treaty, agreement, or statute with respect to hunting, trapping, or fishing, or the control, licensing, or regulation thereof. So Public Law 280 didn't affect hunting and fishing rights. And this is really crucial because where a lot of the Public Law 280 states are often where you have a lot of the problems between non-Indian and Indian hunting and fishing rights. So the non-Indians will often use the conservation argument against Indian tribes, usually Indian individuals, carrying out their federal treaty rights. Why? Well, those federal treaty rights were established long before state conservation regulations. And so they often allow tribal members to break the rules, to violate the rules that all the non-Indians have to follow. Okay? And those are conservation rules, typically. So, and then you have the issue of who's going to enforce the law. The state game and fish agency usually has to enforce the law. So if they enforce the law against somebody who has a federal treaty right that precedes, is superior to a state regulation, then they've got a problem. So that's where a lot of issues popped up back in the 60s and the 70s. We've covered carcieri, so I think. Maybe we didn't. All right. We've talked about trust land and the federal government potentially taking trust land. And, you know, so far all we've really talked about is how the federal government can take original Indian title and extinguish the original Indian title to make it non-Indian land. Okay? Only the federal government can do that. Only the federal government can negotiate with other tribes or countries to get land and then eliminate the title of the previous sovereign on that land, and then open it up for American non-Indian settlement. All right, so we have, in the case of Carcieri versus Salazar in 2009, does anybody recognize any of those names? Salazar? Salazar was the Department of the Interior during I guess it was during the George W. Bush administration. Anyway, what this case was about, it went all the way back to the Indian Reorganization Act of 1934. And this is really, really technical, but very kind of interesting. I think it's really interesting. What Carcieri versus Salazar was about was not taking land out of federal trust, but placing land into federal trust. Okay. So here's a question. Okay, you know, I was telling you about that old log barn thing I did yesterday. The road is being constructed by the Cherokee Nation. The Cherokee Nation had to have me come out and do the documentation to satisfy the the state agency called the Oklahoma State Historic Preservation Office, which carries out federal law, okay? And whenever there's any federal money involved in anything in the landscape, typically road building, road construction like this, federal money requires that anything of archaeological or historical importance be preserved if at all possible. So what happened was the Cherokee Nation building this road ran into a problem with the state of Oklahoma. The state of Oklahoma, which is actually carrying out federal law under the 1966 Historic Preservation Act. And that federal law requires anything that's impacted by federal money, like a road alignment, has to be cleared for any potential loss of archaeological or historic property, okay? So the state of Oklahoma agency told the Cherokee Nation, you guys can't continue on with that road until we have this recorded properly in our records. Yeah. Go
No,
ahead.
okay, so you said recorded. Okay. So like if they were
Well,
to-
actually, if the property was of some great significance and would be potentially National Register eligible, then they would have to divert the road. And that's where they were at this point. So the story I got was it was going to cost them $100,000 more to divert around this old log barn if it were National Register eligible. So they needed somebody to come in and verify that it was not. All right? And so what they'll do is tear the thing down now. Okay? So when you have to do something like that, there is a way, and you go in and you document it and you get a good record of it. So we know it existed at this point some time in the past. But it's never going to be that significant. It's way out in the boondocks, and they need a good road. So, you know, essentially, so that's why they say, okay, well, call that guy at OSU and he'll go out and take care of it and you can move on with your road project. So they were happy to see me so we can get rid of the barn. But it's kind of interesting to me that, okay, the federal government is the one ensuring that it doesn't step on, you know, it doesn't destroy the landscape. Federal trust. Okay, here's the question was, Cherokee Nation's going to pay me for this little job, all right? Cherokee Nation. So do I have to pay federal income tax on that?
Nope.
no.
You don't think so?
I mean,
Oh.
it's
Is it because you're not of the tribe?
Well, it's the Cherokee Nation paying me for work that I did for them on their land.
so no.
So you don't think I'd have to pay federal income tax on that?
Yep.
I don't.
You think
Because
I
you're
wouldn't
not-
have to report it?
You're not of Indian blood?
I'm not of Indian blood.
I don't know.
I
I'm
wouldn't-
just guessing.
I wouldn't think so since it's coming from the tribe, and you don't have to like go through federal like regulations and things like that.
Well, I've done this before. And yeah, I do have to pay federal
Ah.
income tax on it.
I think you gotta go
Dang it.
get the money.
Now, the question is, I would be
Freaking
interested,
awesome if you
I
didn't have
may
to.
not have to pay state
I thought he
income
did,
tax
because if
on
you're
it,
not of Indian blood.
but
you
I don't
pay
know.
it.
I probably do have to pay state income tax on it.
Was it because you were not of?
No, it really has nothing to do with trust land per se. But we'll after the exam, we're going to get into a lot of issues like that: license plates, retailing, gasoline sales, taxation, gaming, all of which is based on whether or not it's trust land or non-trust land. No. Okay, so here's another example. Here's another question. My wife is a citizen of the Cherokee Nation, and she and I are married, and we own a house. Okay, do we have to pay property taxes on that house? She's an Indian. Shouldn't have to pay any taxes.
Yep.
Sorry. I'm making myself laugh this morning. So I don't even do that. Yeah, so we got to pay taxes. Just because an Indian buys property doesn't mean that it's trust land. Okay. So in the case of the 5 tribes, or a lot of the tribes now, but like the Chickasaw Nation, I think I've mentioned this, Chickasaw Nation, Creek Nation, they're like China was 20 years ago. They're like cash heavy, and they're trying to figure out how best to put this. So in the case of the Chinese, they invested it back in the United States, right? In the case of Chickasaw Nation, they're investing a lot of their earnings from gaming. They're investing into land, okay? But this is what's really interesting to me. Say the Chickasaw Nation has, they say they have $10 million of earnings from their gaming operations, and they want to invest that into real estate. Okay, so how many acres can you buy with $10 million? Let's say farmland is 5,000 an acre. It's a little high. Good farmland probably is close to that. I don't know. So how many acres are they going to buy? Well, it doesn't really matter. Let's say they spend all this $10 million on, just say a few 100,000 acres or something like that. 100,000 acres, and so that land is now being used, and this is actually the case down in the Chickasaw Nation. They buy land, they buy private land within their historical boundaries, and then they lease it out to people for cattle ranching. They draw income from that land. They're just like any other investor. They're buying good land that's not going away. They're purchasing assets, and they're putting their earned income into those assets so that they can draw investment capital from it for whatever reason they need. Okay, and that may be operating a hospital or something. Okay, or operating a police force. So they are just like any other investor now. They're putting assets into sort of long-term investments. So the question is, if they're buying up land, is that now trust land? It's purchased by the tribe, owned in common by the tribe.
No.
It's not. Why not?
Because the government didn't give it right out to them, right?
Exactly. So they purchased it, and they're just like any other private landowner. Now the key is they have the option to place it into trust. But they don't do that much. They don't do that much anymore. Why? Because they're not stupid. Right. Because then they couldn't sell it. And it would not be their property. They would not have it anymore. It would go, to put something in trust is to give it to the federal government. Okay? Now, in some cases that makes sense. Like what? Well, as we'll see later, when it comes to gambling and casino gaming and that sort of thing, and those businesses that operate upon a difference between regulation of the state regulation. In other words, sovereignty-based enterprises, like selling tobacco at a price without the excise tax or the lower excise tax, or gambling in a state that otherwise doesn't allow it. Okay, those sovereignty-based types of enterprises have to be located on trust land. So the tribes will purchase land strategically. They'll purchase good locations, right? Place those under trust, because the whole point is to get a good location, right? How geographical is that? That's good. So but if they're just investing, and that's they're buying a lot of land just for investment, it doesn't make any sense whatsoever to put it under trust. Even though that would be theirs, in name, they're not going to be able to draw an income from it. Not like they would if they just owned it